That you have the opportunity today and throughout all your studies to acquire a reasonable and deep knowledge of international human rights and its relevance in the future. In our opinion, promoting the enforcement of international human rights and establishing a well and solid international human rights system through international cooperation and international organizations is a key point in order to make the international human rights, to make human rights being respected worldwide. So that's a key point in our view as an international NGO and non-governmental organization devoted to the promotion and respect of human rights. Today we have the great opportunity to have this conversation with Ms. Patricia V. Well, we all aim you to, after her presentation, to make the questions. It's going to be a dialogue, as the aim of the event is intended, a dialogue between all of you. Don't be afraid of making your questions in Spanish or English. We manage to go through the conversation and to have a good exchange. It's going to be Micaela, my colleague in Amnesty International, who is going to tell you who Patricia V is and why she is a prominent figure in international human rights. Okay? Thank you.
Thank you, Gonzalo. Good morning, everyone, and thank you so much for being here. As a former student of this faculty, it's a pleasure to be here and share this space for international criminal law and human rights law. It's a pleasure to be able to enjoy and learn the Patricia V insight today. The use of sexual violence in armed conflicts is not a phenomenon that only appears in modern day wars. Sexual violence has already taken place in all armed conflicts throughout history, although its visibility is very recent. Thus, from the legend of the abduction of the Sabine women in the origins of the Roman Empire to the massive rape with German women by the Soviet army, or the phenomenon of comfort women, the sexual slave in service of the Japanese army in the Second World War. Historically, is plagued by episodes of organized sexual violence in war context. Since 1919, after the genocides in Rwanda and the armed conflict that devastated the Balkan region, sexual violence as a weapon of war became a matter of public interest after a long period of silence. Its presence in the public debates on armed conflict and its impact in the civilian population has been growing. In March 1994, the UN appointed a special representative for issues on violence against women, with the task of examining the causes and consequences of gender-based violence, of the rape and sexual violence against women and girls. Besides, the jurisprudence of the UN ad hoc international tribunals for the former Yugoslavia and Rwanda classifies systematic rape and other sexual crimes as war crimes, crimes against humanity, and genocide. The Rome Statute of the International Criminal Code, adopted in 1998, developed and expanded on these advantages to give more ground to the prosecution of sexual crimes, including rape and other forms of sexual assault, human trafficking, prostitution, forced pregnancy and sterilization, and any other forms of sexual violence of comparable gravity as a crimes against international law in situations of war, genocide as a crime against humanity. Sexual crimes will not be longer considered mere moral offenses or attacks on honor or good name, as defined by the Geneva Convention. The UN National Security Council acknowledged in 2000 to the adoption of the Resolution 3025 on Women, Peace and Security. The gathered impact of war included its distant, unique and disproportionate impact of armed conflict on women and girls, and also the key role of women in conflict prevention and resolution, and in the construction or consolidation of peace. Patricia Sellers has developed her professional career as international criminal lawyer and special advisor for gender for the Office of the Prosecutor of the International Criminal Court. With more than 2 decades of experience working in the field of international criminal justice and human rights, Mrs. Sellers advised governments, international organizations, and civil society organizations on international criminal law and humanitarian law. She is currently a visiting fellow at Kellogg College of the University of Oxford, where she teaches international criminal law and human rights law. A practicing professor at the London School of Economics and a senior research fellow at the Human Rights Center of the University of California, Berkeley. Mrs. Sellers' expertise focuses on the strategic investigation and prosecution of sexual violence. She was the legal advisor, acting head of the legal advisor section, and a prosecutor at the Yugoslavia Tribunal from 1994 to 2007, and the legal advisor for gender at the Rwanda Tribunal from 1995 to 1999. She developed the legal strategies and was a member of the trial teams of Akayesu, Furunzija, and Kunara. This landmark decision remained the preeminent legal standards for the interpretation of sexual violence as crime of war crimes, crimes against humanity, genocide, torture, and enslavement. Ms. Sellers has been a special legal consultant to UN Women, to the Gender and Women Rights Division for the United Nations High Commissioner for the Human Rights, and to the Secretary General Special Representative for Children and Armed Conflict. In 2012, she was a member of an expert panel to review the UN Office of Internal Oversight that has initial investigative jurisdiction over UN peacekeepers. She has testified as an expert witness before the Inter-American Court on International Obligation to investigate sexual violence. She was a sworn expert witness before the Spanish National Court on issues of genocide and before the Colombia Court in 2 criminal causes concerning sexual violence related to the armed conflicts. Mrs. Sellers has lectured extensively on humanitarian and international law. She is the author of numerous articles and is featured in the Discovery Channel series Why We Hate, produced by Steven Spielberg, and in the acclaimed documentary film The Encuentro. She served as a story consultant on the PBS series Women, Work and Peace, and as advisor on the documentary film The Prosecutor. Finally, Mrs. Sellers is recipient of the prestigious Prominent Women in International Law Award by the American Society of International Law. She holds an honorary doctorate in law from the City University of New York, as well as an honorary fellow for lifetime achievement from the Law School of University of Pennsylvania, her alma mater. Ms. Sellers has also been awarded the National Bar Association Ron Brown International Lawyer Prize and the Global Center for Justice inaugural Janet Beshur Global Justice. And this evening, she will receive the Alicia Salcedo Award by the Bar Association of Oviedo. Patricia, thank you so much for being here, and I know I give you the floor.
Thank you very much. Can I ask permission just to take off my thing while speaking? That's a very generous introduction, and thank you for your hospitality and Gonzalo for your continued support. I'm very honored to be here and actually thrilled to be talking to students because I spend a lot of my time now every year teaching master's students in international criminal law and international human rights law. Among the importance that I give in dialoguing with students is that you're able to ask the question that someone might say, oh, this is very stupid, you should know this legal issue. But you often ask that question about issues that we will be working on 10 years from now, 30 years from now, because they make common sense to you. Because I believe that human rights is very commonsensical if you look at yourself individually as part of the international community. Let me expand upon what I'm saying. For example, today we have the horrendous almost obligation, to follow what is occurring in the Ukraine. When we see refugees fleeing to countries that surround Ukraine, we cannot help but notice that these are gendered populations, that we're basically seeing females fleeing, whether they're adults or children, and we're seeing boys, and then we're seeing older men who are not fighting in Ukraine. And we see who is basically staying in Ukraine, another gender population of males. Those are males that are basically of fighting age that will engage in combat. If we could just take that paradigm and understand that that paradigm is very gendered and it intersects with several bodies of human rights type of law, or humanitarian law. For example, refugee law. If refugee law is not gendered, it will not pick up how to protect the population that is fleeing. Human rights law. We know that human rights law does not stop, is not abrogated in times of armed conflict, that there are fundamental human rights that cannot be committed or that have to be protected by the state, even during armed conflict, such as torture, such as enslavement. And I would argue such as slave trading, which I'll talk about a little bit later, which is basically the name that has become trafficking. But under international criminal law, we talk about slave trading. And we also know that you cannot arbitrarily kill persons, even during time periods of armed conflict, from a human rights paradigm. In addition to that, we have to apply international criminal law, which means crimes against humanity, that those two populations that are gendered, the males inside of Ukraine or the fleeing women, still have the right to be protected under crimes against humanity. They cannot be placed in detention, tortured, or forcibly transferred. And lastly, we see that humanitarian law itself, the law of armed conflict, applies right now on the territory of Ukraine, but possibly also outside of the territory if their actors are involved. Now, this is almost all that I'm going to say in Ukraine today, but I wanted to show you that by its very nature, we're looking at a gendered conflict, and therefore we must have a gendered perspective in all of the legal regimes, including human rights that apply. But just take that very same picture and let's go back to Syria, or let's go back to armed conflicts that might have occurred in Sierra Leone, and even back to the genocide of Rwanda and Yugoslavia. And in looking backwards, you can see that if we do not have a gendered perspective, analysis, contextualization of the law, we are not addressing the horrors of crimes against humanity, genocide, or armed conflict. So let me give you just 2 or 3 examples, and I think for students it's particularly important, because somewhere we want to place human rights on this almost unreachable goal. We either say, oh, it's the perfect law, therefore it's universal, it always applies. But when we come down to its actual application, we're always seeing problems. And often these problems are related to, well, there might be cultural differences. And maybe some human rights should apply to some groups, but maybe not necessarily to other groups. Or this is a very Western-driven project, human rights. And what we're trying to do is be missionaries with human rights so that industries can come in and take over countries that are not necessarily from, in quotes, the West. Well, I'll remind you that the West is a political project. The West is geographical. The West is not necessarily a conceptual idea that holds when we talk about human rights. Many of my former witnesses were persons that I've seen, whether at the Rwanda Tribunal, at the Yugoslav Tribunal, or when I have been giving advice to other countries and civil societies around the world, who is calling for the universality of human rights are the victims and survivors. They are not saying, do not bring your Western human rights to me. They have never questioned whether genocide or torture was too Western to apply to their circumstances. In the work that I did with the Comfort Women, that brought together 9 different country teams from South Asia, but also from Australia and from the Netherlands, they never questioned whether enslavement and enslavement via sexual violence was far too Western to be applied to their context. And so I would ask all students not to just assume that human rights are per se Western, but to really look from the survivor and the victim-centered perspective of what is a protection that not only they need, that they should enjoy, but they have the right as rights bearers to claim. The other thing that I would really emphasize, and particularly with students, is not to remove yourself from the equation. Human rights do not sit out there. They sit exactly where you are sitting. They are within you. If you think of human rights as missionary work, it is because you have artificially placed a barrier between yourself and the possibility of the law. We all come from and exist in situations that require human rights. Right now, you're accessing the right to education, a right that's been discussed that Yazidi women didn't have when they were captured, that Afghan girls even might not have in post-armed conflict, that many children around the world, girls and boys, would love to access on a daily basis. You're enjoying that human right now by being present. You're also enjoying the human right of freedom of assembly. The fact that you could come together in this room. You're enjoying the human right of freedom of expression, in that you're listening to me expressing my ideas, and soon I will hear you express your ideas. Human rights should not be foreign to you. You exercise them every day as a human being, and they're extremely important to you. And so when we look at the exercise for other persons who might systematically have their rights denied, or even intermittently have their rights denied, we should understand that as a human being to a human being, not as a mission. Among the other things that I'm often in discussion with my students is that we think that atrocities sit, again, far away, geographically far away, or conceptually far away. Oh, this could never happen here. I remind my students that one of the things that they should do is try and find out what genocide group they belong to in case a genocide occurs. Now, a genocide is something that we think of as extraordinary and unusual. I would agree. But these are issues that Canadians are dealing with today. These are issues that historically that have occurred in the United States with our indigenous population and in Australia just decades ago. They are not so far away. Examples that we've seen in Rwanda and in Cambodia and in the former Yugoslavia are examples that are not necessarily the exception, because how these types of genocides occurred was in daily rebel rousing that became nationalism, that became othering their own citizens. These were not foreign armies that walked across borders to create genocide. These were acts among nationals. One of the most stunning cases that has occurred in the past 20 years, and I would say other than the ones that I've worked on, occurred in Guatemala. And it was a case with Rio Mutz and then with Sepulsada, that for the first time in the world, but particularly in the Americas, the crime of genocide was applied and recognized that a group of Ixil Mayans had had a genocide perpetrated in Guatemala. But it didn't go back 500 years, although we know that from some indigenous populations, they would claim that there has been 500 years of genocide. But it looked at some very temporal acts that occurred in Guatemala between the 80s and the 90s that looked at and targeted the Ixil Mayan population, but also targeted municipalities or intellectuals who went to universities or who taught at universities, were killed, detained, placed in secret police detentions, and disappeared. They're people who are very much like you, not removed at all. And they were targeted under crimes against humanity because they were expressing the very rights that you're sitting in this room and enjoying today. So the lesson that I would really try and emphasize to you, it is not about them or the other. It is also about us. Crimes against humanity are crimes against us, and genocide
any crimes against us. So as we're learning about human rights and international criminal law, it should be because we really want to strengthen humanity, because we as humans enjoy many of those rights and have to protect against those rights being taken away and placed asunder. It happens incrementally. It happens gradually. In the situation of Rwanda, although we look at the genocide that occurred in 1994, if you talk to many Rwandans who have lived through the 1994 genocide, they will tell you that there have been many, meaning M-I-N-I, tiny genocides that had occurred since 1960. It's the 1994 genocide that blew up to such a great scale. If you talk to the Yazidi community in Iraq, they tell you, we've had more than 90 genocides committed against us. This is the most recent. So I'd like to make sure that we bring that knowledge and that experience much more down to earth, much more understanding the possibilities of human rights violations, international criminal law violations, not that can occur, but that do occur. I think in Europe, we have this notion that there has been peace for 50 years since the creation of the European Union. And that is part of the horror in which we're seeing the events play out today of having broken this peace. But we have to understand, too, that within geographical Europe, there was the war in the Balkans. We are eternally grateful that most of the breaking down of the former colonial nature of the Soviet Union happened peacefully when the wall came down. But in the other parts of the world, during these past 50 to 60 years, there have been horrendous wars of decolonization. There have been horrendous civil strife of anti-apartheidism, or strifes against racism. I think that we are incredibly lucky that most of the increasing rights that we see given to women have been done peacefully. There have been very few camouflage-wearing women going to war against their governments, becoming guerrillas to get female human rights. We have to understand that there is a way to peacefully accede to more rights, while acknowledging that the peace that we often celebrate has not been peaceful situations for different groups around the world. And most of that violence has occurred because of a denial of human rights or protection of humanitarian law. So I want to leave my remarks there, and I hope I've given the students something to think about. And particularly, I ask you to bring yourself to your questions and to your issues as we dialogue together on humanitarian law, international criminal law, or human rights law. Thank you.
Now time for the questions.
In English or Spanish if you want.
Well, I'll try because my English isn't so good. Do you think, because nowadays we're right to International Criminal Court and Tribunal Strasbourg, European Human Rights Court and other courts, it begins with voluntary previous act of submission by the governments, by the countries. But do you think it would be possible someday to have intervene, judge criminal acts, individuals, without needing previous consent by the governments or the countries they belong to? I don't know if you understand that. Okay.
I think I do. Let me preface before I say anything. I should have said at the beginning, of course, that I'm speaking in my individual capacity. I'm not representing the policies of the Office of the Prosecutor or any institutions to which I'm affiliated, such as Oxford. Your question, it really goes to the heart of jurisdiction and whether you consent to jurisdiction or not, and how the International Criminal Court is constructed. It is states that consent to jurisdiction. Individuals who are accused of crimes under the Rome Statute can contest whether the court has jurisdiction over them, but that's because of the nature of the allegations of the crimes. They can't contest whether the state that they come from has succeeded to the jurisdiction of the court. So do I ever think that we'll have an international court system whereby we don't go through states and we go via individuals? Well, I think that there is something that you know in law, period, but in particularly in international law, that really recognizes sovereignty. And when states accede to jurisdiction, they see it as giving up a bit of their sovereignty. And since Westphalia, we know that state sovereignty has been part of the key of how the international law works. At the same time, I would argue that we are seeing, whether it be from civil society or whether it be from other ways that we're allowing individuals to have the ability to contest sovereignty when it doesn't protect them. We do see that growing. Will that ever mean that an individual can ask for jurisdiction over a matter, even if a state, denies or contests that jurisdiction? Well, the easy answer is, I don't know. But I think that there is some movement to understand the legitimacy of the sovereignty of the people. We're still using concepts of sovereignty, but the sovereignty of the people or of individuals. And that's where we see things such as the rights of aliens within a different nation, some of the rights of refugees or persons who are seeking asylum. So we're seeing little slithers of that occur now. And the other side of that is when we see when persons, for example, who've been tortured can argue that their state in the exercise of their sovereignty did not exercise due diligence, and that they should have the rights to go to treaty bodies, whether the state agrees with it or not. We see that in some of the regional court mechanisms, human rights court mechanisms, and in the treaty body mechanisms of the United Nations.
Sorry, in relation to that, what about the universal jurisdiction?
Well, universal jurisdiction presupposes that the state with universal jurisdiction has accepted a type of competency. So we're still back to that state sovereignty. But I think that the universal jurisdiction also is a way of empowering individuals, not necessarily in their own national state. They can go to a third state and ask for that type of protection. That's a very good example.
Spain, it was a good example in the past with Pinochet,
Right.
but the law has changed.
Political, right?
You have to go first. Okay, if you want to.
So me or you? Okay.
I don't know.
Would you consider that the international accusations placed, for example, by President Biden against Putin because of the supposed war crimes that he has committed because of attacking protected locations in Ukraine, such as hospitals or population he shouldn't attack, can have an actual effect in the international court or, any response internationally against him?
Well, I think President Biden offered his view, his opinion. At the international court, you have to offer the judges evidence. And so I think that sometimes many people say, well, I saw it on TV, there's the proof. Or this person said that, so there's the proof. But for the judge of the pretrial chamber, that might be proof if it were substantiated in different ways. But that's basically voicing of an opinion.
And if there, eventually was a trial, do you think there would be effects against Putin that he would actually suffer if he was actually accused and judged for committing war crimes? Because he is such an important and very protected world leader?
Well, you stated if he were convicted
Yes.
or acquitted. Well, if he came before a court, maybe the international court or universal court, and if he were convicted, I would assume that he would suffer, because someone who's convicted of crimes and they were physically present might have to then have penal sanctions applied against them.
Thank you.
Right. But let me just say, one of the things that you said by your first question, saying someone is a war criminal has to be an adjudicated finding eventually. And that's why it's an opinion before any evidence is gone forward.
Me now. Good morning all. My name is Regina Fonseca. I'm a penal law professor here at the University of Oviedo. And it's a honor for us to have you here, Patricia. And I see that there are many students here. So first thing that I would like to ask you is that we know Patricia today, and I would like you to go forward and say, oh, when I was a student, what did I have to do to become Patricia today? So we have an opportunity to hear from you what they can do, thinking about their career for the future. And then I would like to ask you a question about if the ICC, my background is domestic law. I'm from Brazil, and I have worked for 20 years as a prosecutor, as a public prosecutor, as a district attorney. And so I had contact with many victims of sexual crimes, sexual violence, but in the domestic level. I mean, I never went to the ICC, so my background is more like a state law. And I would like to know if the ICC is already using AI, artificial intelligence, because I think there must be some gender at the IA, We already use it here in Spain. Policy use IA for diagnosis of risk of gender violence cases. And it's interesting because you have to have a bias, a gender bias on the IA. And I was thinking about like command responsibility, if the IA can give you proof on that. No, on Putin or what else. If the ICC is already using IA, in which extent and for what purposes? It's a practical.
Let me answer your second question first. To my knowledge, okay, a big caveat. I do not know if they're using IA in the sense that you're using. We're not about predicting a crime that would occur, but addressing a situation where there might have been criminal activity. But related to your question, part of the gender analysis is to contextualize the violence. And under several of the responsibility theories, such as command responsibility, or such as under customary law, what's called joint criminal enterprise, or collective participation, similar to some things in domestic law, you have to look at what's foreseeable. And remember, you can't remember, you're far too young. Well, try, okay. 40 or 50 years ago, or maybe up until today, there used to be what was just a familiar shrug. Oh, rape happened during war. What do you expect, okay? There's going to be war, there's going to be rape. Yeah. But just by shrugging and saying, what do you expect, means that it's foreseeable, right? Mm-hmm. You must expect something. You must be able to, if not predict, understand circumstances and situations where sexual violence could occur. So, for example, at the Yugoslav tribunal, there was no AI, there was no algorithm that we could put in and say what would happen. But we did notice certain patterns, and for example, within detention centers, and the Yugoslav conflict in many ways was based upon a series of detention centers set up by Bosnian Serbs and by Bosnian Muslims and by some Bosnian Croats. And we noticed that in detention centers, males were sexually violated. There were patterns that would pop up. If you had a male population, those males would be sexually violated in specific patterns, such as taking out 2 or 3 men at a time and doing some sexually violent act, making them do it against each other in front of the other males. And they would do it usually once as a public event, and the person ordering or making them do it physically stayed outside of the sexual violence. And it was often a way to terrorize the males who were looking. And we would gradually find that pattern picking up so that we would know when going into a detention center, we should be alert that male sexual violence usually occurred here. And there were other patterns for female sexual violence, where that sexual violence had females that usually were taken away from the rest of the female population, sexually violated in separate rooms. And it often occurred more than once, whereas the males might have occurred once and sent signals to the male. So it wasn't artificial intelligence, but it is what we now call contextualization. We understand that when certain crimes occur, such as imprisonment, detention, forms of physical violence and starvation, that you were very likely going to have male and or female sexual violence occurring simultaneously or periodically. So that's part of what, as a matter of fact, you referred to, the strategic investigation of understanding what you are possibly going to encounter as you're investigating. Right now, we can use some of that strategic investigation when we understand child soldiers. That many child soldiers that are females, we know somewhere have been encapsulated in sexual violence, and now we're starting to understand, well, also the boy child soldiers up until 18 years. So artificial intelligence in that sense. In terms of your first question, I too was a law student like many of you, and when I was in law school in Philadelphia and Pennsylvania, I mean, my wish was to be a public defender, and so when I left law school, I became a public defender, a criminal defense defender within Philadelphia County. And at the same time, what I'd been doing while in law school and then when I got out of law school was volunteering, doing volunteer human rights work. And Philadelphia is a city that was the national headquarters of the American Friends Service Committee, which is commonly called the Quakers, who have been pacifist American entity for 300 or 400 years. And so with the Quakers, I did several human rights missions in Puerto Rico and the rest of the Caribbean and Nicaragua and within the United States and speaking. So how do you get into this field? At that time period, this field really didn't exist. But I know that I really enjoyed human rights from a personal perspective and from a legal perspective, and I very much enjoyed criminal law. And I was at the point in time when Yugoslav Tribunal was set up, to be able to wed those two passions of mine as it related to law. After I practiced law in Philadelphia, I moved to Brazil for 3 years and worked as a human rights officer at the Ford Foundation and was looking at issues of Afro-Brazilian discrimination and also landowners, and then what used to be called favelas, now referred to as comunidades, of poor internal immigrants around major metropolitan areas within Brazil, where there was a host of human rights types of issues that came up. And so that also informed me, as I later on worked for Rwanda and Yugoslavia, that you understood that the violations, their complexity, come grouped together. And that you're rarely just looking at a murder. Usually the person who's been murdered is related to a family whose house has been burned, whose cows and horses have been taken, and it's just grouping together. So that became my way, but I think today there are so many different avenues in which to enter into international human rights law, international criminal law, or humanitarian law. In terms of being a prosecutor like yourself, there were several former prosecutors, domestic prosecutors, who integrated into the Yugoslav and Rwanda tribunal. I myself think that's an excellent background to bring, to be a prosecutor or a public defender and coming to those, because some of the skills that you use are basic criminal prosecution skills, knowing how to take a witness, knowing how to preserve evidence, what's a chain of custody, what's a good cross-examination, knowing how to be contrite in front of a judge, knowing how to not fall to the defense counsel's, hiding of evidence, and all of these little things that you pick up just by doing bread and butter national prosecutions, I believe.
Thank you.
Yeah.
Among all the situations you have faced during your career, which one would you consider the most difficult to face or to solve?
Yeah, I mean, it's hard because I have to say there's so many. They touch you in different ways, you know, and to say which is the hardest or which is that. Some you don't realize until years later how hard it was because you were giving yourself a protective barrier while you were there. And then later on you realize, oh, hope I never have to go through that again. Well, I think one of the things that was very, very hard was talking to a witness once who was relating her sexual violence. She was being violently raped, and she kept trying to draw the attention of the person, the man who was raping her, to her, because she had looked over and saw underneath the curtain that her daughter was standing, and that she didn't know whether the daughter had been violated or not, but she just wanted to make sure, let me keep his attention, so that, and you know, while you're taking down the statement or you're having a discussion like that, you're trying to make sure you have it accurate, but you certainly understand that this is far beyond the situation of what is physically occurring. I think there are other times that that you realize too, and it always goes back to the humanity of the person. I was in Rwanda assisting in an interview with another colleague about a man's wife who had been killed during the Rwanda genocide. And how she had been killed was they had inserted a type of knife or spear up her vagina until it came to her throat. Horrendous, horrendous. And the man turns and says, when they were asking questions, you know, his wife, he says, yes, she looks just like you. You know, and so that you're the interpolation of all of the facts and yourself included. But there are many incidences, but what I really want to emphasize too is that we're dealing with human beings and human potential, and just for the persons to be able to relate that back, you know, within a context of whether they're taking a statement. I mean, there have been other times that I've just been amazed and have felt grateful to be in the situation. There was one time when one of the sexual assault survivors within Yugoslavia was telling me that they had lined the women up against the wall, and they were supposedly going to shoot them. And then one of the women somehow had kind of like a sleeping pill that she took, and she was starting to get drowsy. And the other woman said, can't you at least stay awake until they shoot us? And that all the women against the wall broke out laughing. And I didn't expect a joke to be told at that time period, but you know, that's what humanity, you know, can and will do to you. So it's all of absolutely extraordinarily humane moments that stick in my mind in the long run.
Yes, about the situation in Ukraine, for example, like a week ago I read an article about being cases of people waiting for women that cross the border and take advantage of their situation or desperation, like most women don't have money, for example, and they take advantage of that to lure them into prostitution, for example. So my question, I guess, is there a way to control those cases? If, how we can help, how international law can help in that?
Mm-hmm. Right. Well, one of the things that I'm working on, in particular for the past 5 years, is trying to make the legal community and civil society, along with some of my discussions at the court, to understand that there is slavery and there is slave trading. And that right now in our legal communities, we've basically looked at issues of trafficking as opposed to, instead of in addition to looking at trafficking and slave trading, and that the two of these are different. So I've spent some time not only writing but speaking on this, and the emphasis is the following. Slavery and slave trading go hand in hand. Before you become a slave, you have to be traded, which means exchanged, given, bought, sold, or just disposed of in a manner that you are no longer, in quotes, a free person, you are enslaved. And so what we often see happening to certain refugee populations or certain vulnerable populations is that they are prey, they are easy targets for people who want to enslave persons sexually. And we call that trafficking because we're thinking of the international treaties on trafficking, which were called white slavery, that come from the 1910, 1920, 1930. But trafficking is about reducing someone to a form of exploitation. Trafficking is not an international crime, it's a transnational crime. Slave trading is the international crime that goes with the international crime of slavery. And with slave trading, you don't have to prove that the person then became sexually exploited or slave. All you have to prove is that was the intent of the perpetrator to reduce them to that situation. Much like slavery depends upon the intent of the perpetrator to exercise powers of ownership. So in essence, by moving to this trafficking model, we've made it harder for ourselves to pick up people who basically are slave trading vulnerable populations, females, but often males, into situations of enslavement. And let me just conclude with this. It might be for good intentions, even feminist intentions, that we talk about trafficking. But somewhere we're denying the historical position that slave trade has under international criminal law, and its historical, how can I say, its historical motivation when we look at both North and South America, Brazil, that are countries that result from the slave trade. And that slave trade included at least 50 to 53% of females and of girls. And most of the slave trading in the Americas was not the transatlantic. Most of it occurred after the slaves get to the United States, the Caribbean, Brazil, Colombia, and they're internally traded. You know, they're moved from Sao Paulo to Recife, or from Charleston to New Orleans. So today, when we have this legal paradigm of trafficking, which is really a type of organized crime, and coming from a transnational point of view, we take away one of our best legal tools of recognizing that some of these women or girls or boys, because they're vulnerable, because they don't know if their families are alive in Ukraine anymore, or they don't know how they're going to work, even though they've been, you know, in quotes, rescued from the bombs, they might start to be slave trade. And I don't think we should throw away that legal tool, because it is much more useful in some situations than we can imagine.
Hi. I want to ask you two questions. The first one is, how do you feel in a very male-dominant career? I think that's the word. And the second one is, how do you feel? Well, at least I feel like in Latin America there's a lot of problems and dictatorships and all that. And as you were talking, indigenous people, they're still suffering all these horrible things about rape and all that. Don't you think that humanitarian law should be like more into that? I don't know if I'm explaining myself, but they're like, they should be doing more than they're doing, because kids are dying, women are being raped, and they're dying in horrible ways. And because in Paraguay, in Colombia, and Bolivia, there's all these indigenous groups that are being murdered and nobody cares, really. Well, I think that we're not paying enough attention as we should be.
Yeah. Well, in terms of a male-dominated field, I would say that international humanitarian law, international criminal law, and to a certain extent human rights law, does have extreme male perspectives. But if you look around the room today, which is happening increasingly, is that the human rights student is female. I think that's happening around the world, to tell you the truth. The international humanitarian law student isn't necessarily female. I was going to speak a bit about that later on this evening. And the international criminal law student is, I would say, is reaching about a 40-60 mixture. But that is different from the concerns of those areas of law and how are the legal regimes being used to protect and alleviate the harm. So for example, in Colombia, and I've had the ability to go in and out of Colombia maybe 10 to 12 times during the past decade, and particularly to look at issues of the armed conflict, and in particular issues of sexual violence that have occurred. And I think that the long-term armed conflict in Colombia involved many communities, indigenous communities, Afro-Colombian communities, urban communities, rural communities, communities of LGBTIQ who were sexually targeted during the armed conflict or because of their material conditions after the armed conflict have been susceptible to sexual violence. And so the question that I think you're raising is why haven't entities such as the HEP or before the law of Justicia and Paz, why haven't they responded to it more? Well, I would argue that there has been a bit of a sea change in Colombia just by the fact that you're asking this question. And that has to do because civil society has been pounding this issue. That we know that within the Justicia and Paz, which addressed the paramilitaries in Colombia, and said, look, if you confess to your crimes, you get 8 years, which is kind of like a sale, do this and we'll give you that. And they found out that most of the paramilitaries will confess to murder, but confess to rape? No, I don't, yes, I kill, I plunder, but I don't rape, And so there were several cases of paramilitaries who then had to go through the judicial process, such as El Oso and Sucre, because they wouldn't confess to this, but then they ended up being convicted of sexual violence. And in the case of El Oso, where I was the expert, that men in his battalion first pleaded guilty, and then he had to plead guilty. So we still find that phenomenon of sexual violence at times being the worst thing to confess to, and particularly from a masculine perspective of, I don't have to rape women, women come to me, okay? And that's just heteronormative rape, and that's where some of that is coming from. We've had persons at the Rwanda tribunal who would plead guilty to mass killing, but not to sexual violence. That's not them, as if there was a moral hierarchy within their mind. But then your current question in terms of the HEP that's working in Colombia now, and whether they'll open up a national case that relates to sexual violence. That is still something that seems to be very contentious. But what is without doubt is that Colombia has suffered a war where there is killing, where there is sexual violence, where there is homophobia, and where those issues, when they are not addressed, will continue to drive certain sectors of Colombian society into denial. And what the legal process does at times in transitional justice, it stops the ability to deny what is basically the truth.
So first of all, I would like to thank you for such an interesting intervention, and you are also so thankful for having me here today and having the opportunity to share this dialogue. And I would like to ask you about the role of the Western world human rights wise. We were talking about that before, and it really interests me because do you think when putting into practice human rights, do we as Westerners look down in some way on the rest of the world, the cultural diversity our world has, the different countries among continents? Do you think we somehow underestimate the rest of the perspectives?
Well, that's a trick question, right? No, not really. Well, we all come with our perspectives and our prejudices. And we've all been schooled to see the world in one way and have to almost uneducate ourselves, uneducate our miseducation to understand the world in different ways. I think that I've seen those privileges from very many sides. One is being an African American in the United States. You know, I can understand, you know, and read the constitutions and see all of the, what do you want to call the breaches of justice. At the same time, as an American traveling the world, I can understand the privilege that one gets from being an American as opposed to being from El Salvador, right? I can understand also the privilege that I have because I've gone to university like you have, as opposed to, you know, selling apples on the street. So yes, we all come with different prejudices from our own experiences, and I think it's incumbent upon us to unlearn those and relearn other ways of seeing. But I do not think, I seriously do not think that the basis of protection that we're seeking with international criminal law or humanitarian law or human rights law is purely Western. I think its application at times might be selective. I think that its ability to respond might be curtailed by instances of political will, by actual funding, by disconnecting it possibly from democracy or from the rights bearers that are part of the civilian population, irrespective of where they are globally, or part of a genocide group, irrespective of whether it's from the north, the south, or whether it's children being sent to school against their parents' wishes 10,000 miles away or not. I think as Westerners, not only must we question the prejudice that could come up that normally makes a Western point of view seem a valid point of view, I think that we have to question that, not so that we're not being condescending, but so that we can finally become true human beings to ourselves, even in our own context in which we are. The Western perspective, for example, did not safeguard Spain, Europe, United States from misogyny and gender prejudice. So obviously it must have some cracks in it. At the same time, when one really looks at some of the feminist theories and practices of Latin America, this entire issue now of femicidio, this comes from what might be called a non-Western experience. When we look at our ecological human rights that are starting to evolve, most indigenous communities have been doing this for millennia, to have circular economies. So I think that we can grow beyond our prejudices on any given day if we're willing to give up that power.
In addition to what you have said, it comes to my mind that the perspective was north and south. You know, Westerns and Easterns, no? Like United Nations coined the global south to use a different designation for the underdeveloped countries. And I would like to know, as a teacher, because you are a lecturer at Oxford, at the University of Oxford, and I see that Oxford was working with this perspective, north and south, as, for example, the Center for Criminology. They have a group, a discussion group on southernizing criminology. And what type of movements from these perspectives do you see at the university?
Well, again, I can't speak on behalf of the policies of the university, my own personal point of view,
Yes.
but certainly we do not have that type of perspective in my classes. Let me be very clear on that. And that I charge my students with trying to decolonize themselves, you know, and myself, you know, and that starts with vocabulary, that starts with concepts. And I'll just give one example. Every time we speak about the global north as a code word for everything that's evolved and developed, we per se ignore that there are populations in the global north who remain colonized today. So when we look at Greenland or indigenous populations within Canada, the United States, or Mexico, we're almost continuing to deny their existence by presuming that global north means everything is fine, evolved, there are no human rights issues, there are no continuing colonization. Every time that we state, oh, the global south, as if we have to bring knowledge and technology to, we're denying probably the existence of Costa Rica, which is one of the few countries in the world that is self-sustainable in terms of energy. So who is really losing out on knowledge when we keep reinforcing our own ignorance? So that's the perspective that I would take.
Last one, I'm repeating, but it's not the same question. It's something related to, well, first of all, congratulations for your trajectory, and thank you very much for sharing your time with us. And I apologize again because my language skills are not, the speaking skills are not very as bright as the students are. It's about a universal justice that my fellow teacher suggests. I'm asking you again your personal intuition. I know there is no general knowledge maybe about the question. In Spain, we end the universal justice because of external pressures. In our case was China that says, okay, if just China threats the Spanish government of stopping buying the external debt, the external debt, and 80% of our external debt is being bought by China government. So sadly, our legislator decided to end up the universal justice. We have lots of cases of Guatemala, of China leaders, even Guantanamo cases, Afghanistan secret prisons, lots of cases already with proofs and documented. What do you think? I think in Europe it's only France and Germany who are still fighting from universal justice point of view. But what do you think? I don't know what's the USA practice in this internal. I know it's an internal thing, not an international thing. But what do you think? Do you think humanitarian or law values principles will prevail, or would economic reasons, external pressure overcome or make countries give it up? What do you think is going to be the trajectory?
Right. Well, I think you brought up another good point, and as I stated before, there are issues of state sovereignty. There are also issues of economic pressure, and that universal jurisdiction seems to be going through a wave where it's becoming a bit more acceptable in certain circumstances. Remember the cases that Spain had, and particularly with Mexico, some that related to Argentina and to Guatemala, where I testified, they were shut down due to political pressure. And often that pressure, in addition to economic, was that our diplomats won't be able to travel if we have universal jurisdiction. Okay, and diplomats need to travel. That was among the reasons that in Belgium, the universal jurisdiction started to be cut back because Brussels, as we know right now, is having these different summits. At the same time, there was this fear that the different political heads or military heads were being falsely accused, and therefore universal jurisdiction was being abused. And so we saw kind of like a retreating of universal jurisdiction. Today we're seeing a slight enlargement of it because of the means and how Germany and France are using it to go after persons who they've alleged, and now some have convicted, who took part in the armed conflict in Syria. So undeniably there is a utility in universal jurisdiction because those international crimes are supposed to be crimes that affect the entire international community, and therefore states are supposed to have the duty to either prosecute or send to a jurisdiction that will prosecute. But we're not at such a high implementation period, but it's usually events that push its implementation and its retreating. It's very good that you point out that those events also might be economic. What we're seeing today is that some of the world's debt, such as the United States, as you just mentioned Spain, are held by third countries, and that they can turn the holding of that debt into political interference. In the United States, there is not a lot of universal jurisdiction. There's been what's called Alien Tort Claims Act, that if someone inside the country had been abused by human rights outside the country, they could bring alien tort claims. But even that has been narrowed down by the US Supreme Court, because the alien tort was this strange law that appeared in the 1700s in the United States. And so now they're saying, well, what human rights existed in the 1700s, and only those can be human rights that can be enforced in 2022 about persons who might have been convicted. So we see somewhere that universal jurisdiction is a great opportunity, but one that is limited and pounded completely. I have noticed in the past 5 years that there have been many more civil rights organizations, civil society organizations, and particularly legal organizations, that have taken the chance of using it. And the more cases we have based upon universal jurisdiction, we can see that it's a tool that can be implemented and that can be used not just for frivolous cases, but in order to really protect the international community. And therefore, I think that it will grow. But you will always, always have pushback from it, because it's a powerfully dangerous tool if it were really to work.
Well, first of all, thank you for being here. We have talked about indigenous communities in the American continent, and I would like to ask something related to that, which is if it is not better, well, indigenous communities usually have like special laws applied to them, and they are treated as eternal minors. They have their territories with special laws and this type of things. And also, for example, the US through the UNESCO has founded schools in indigenous languages, so the indigenous people don't speak, for example, Spanish. So they are quite isolated from the rest of the American country society. So isn't it better to, instead of differentiate them, to make them complete citizens in the context of their countries? For example, in the Fidel Castro's Cuba, they forbid Afro-American associations because they understood that divided the Cuban society. We are not white or blacks or whatever, or indigenous people. We are Cubans, and we have all the same rights. So isn't it better to, instead of try to differentiate them, to make them all equal to the rest of the citizens?
Mm-hmm. Well, you know, the challenge of, and particularly the Americas, and I think it's coming more to Europe, is that the Americas, North and South, and the Caribbean were built upon three basic populations. And it's the populations of indigenous communities and societies. It was the populations of enslaved persons that were brought there, and the population of Europeans that came via various immigrations, okay? Some didn't immigrate. For example, the state of Georgia in the United States used to be a penal colony, so the former convicts didn't immigrate, they were placed there, they were dumped there like in Australia. So there are exceptions, so I'm not speaking so generally that I don't understand the subtleties. But if you notice on the money in the Americas, almost every motto of every country, every lema is how to go from many to one. This tension of these different groups coming, and how do we make that a united? The United States is e pluribus unum. But if you look at the money of Mexico, you look at the money of Brazil, it's always about how do we turn these different populations into a nation. I say that to say my response to you in terms of differentiations of those populations is that under international human rights law, international criminal law, humanitarian law, for those purposes, those populations are either part of the civilian population or they're part of protected groups, irrespective of what their national context might be, or they're part of genocide groups. And I think that that has to be recognized. They are rights holders per se. Whether they're integrated in their national context or not is not the question at the international sphere. One must note also that there's a declaration in terms of indigenous peoples and communities, but there's yet to be a convention. I myself do not think that we have to erase the past histories of these populations, and that populations can have different organizations and societies and still at the same time represent the citizenry of their country for national laws or for regional laws. So I don't think we have to enter into the either this or that. But I do recognize that this has been a tension of the Americas. And right now we see it in Europe. We see France that's trying to say, well, are you French, or does a French society, is it able to incorporate immigrants who might not be French from 2 generations ago? And this is a continual question I think Europe will be facing increasingly, but one that the Americas has faced for the past 300 years. And similar situations are occurring in Africa.
So the Spanish government has just recently decided to start a dialogue with Morocco in regards of the Occidental Sahara territory and population, and they are determined to recognize Morocco's sovereignty over the territory, and at the same time recognize that this territory has some sort of autonomy, and so since the UN has recognized since 2002 that theoretically Spain is the country that has the administration of this territory, do you think it's the best choice to recognize, consider that this territory is part of Morocco, or what are your views about that?
Well, I think Gonzalo has to answer that.
Well, the question was for you. I will tell you something, and later, please, if you want to add something about that, that would be useful for the student. Well, in this case, the key point when we are talking about the Western Sahara is that the Western Sahara is, according to the United Nations chart, is a non-autonomous territory. I mean, it's a territory that is meant to proceed with the process of decolonization. So the United Nations chart establishes very clearly that all the colonized people has the right to self-determination, and that is the key question. In 1973, the General Assembly of the United Nations declared that the Western Sahara was to be included in the list of the non-autonomous territories, and therefore all the administrative powers has the obligation to promote the self-determination process. An obligation in which it is clear that Spain failed when Spain abandoned the territory in 1975 to 1976 without having finished the colonization process, and just saying in an unilateral way that its obligations regarding the Western Sahara had finished, which was not the case. So at this moment, the key question is not whether the Sahara territory is going to be part of Morocco under an autonomy status, or whether it is going to be independent. The key question is who is going to decide that. That's the key question. And according to the international law, it is clear that it is upon the Sahrawi people the right to decide. and not the Morocco people that has been moved from the north, from Morocco to the Sahrawi territory among these years, because there is a real process of colonization of the Sahrawi territory. It is from a human perspective and how to deal with this situation is a very difficult, it's a controversy without any easy solution, because several 100,000 people from Morocco have been moved since the early 90s to the Sahrawi territory, and indeed the Sahrawi people that live in the non-autonomous territory, what they call the occupied territory, are a minority in their own country at this moment. But the key question is, who has the right to decide? The Moroccan, the people from Morocco that have been moved and that at the end are part of a colonization process, or just the Sahrawi people that live in the Sahara, in the Western Sahara, and in exile in the Algeria refugee camps and all over the world as a part of a modern diaspora. So the solution to this equation from an international law perspective is that it is only the Sahrawi people who have the right to decide. And for sure, if Spain decides to agree with the sovereign of Morocco for this territory, just asking for a kind of autonomy, it is a decision that deprives the Sahrawi people from the right to decide. So at the end, it's a decision contrary to international law. And at the end, what kind of autonomy they are going to have? An autonomy where the right to participate in the public decisions that relate to the Sahrawi autonomy are going to be a right granted for only for the Sahrawi, or also for the people from Morocco that have been part of a colonization. The result of an autonomy would be total discrimination of the Sahrawi people, as they are totally discriminated now. It is a question, some organizations, it's a difficult question from a legal perspective point of view, because the international crime of apartheid, there is a convention against the international crime of apartheid, and it's being discussed if, in addition to what everyone knows as a case of apartheid, the South Africa case, if there is other cases of apartheid, and it is being initially discussed if the Sahrawi people in its own country, in the Western Sahara, are subject to apartheid, as, for example, the Palestine people in the occupied territories are indeed submitted to apartheid. So it's a very, very difficult question, but where it is a question totally dominated by pressures from great powers, from France, from the United States, and the decision of the Spanish government is totally driven for political interest and for this kind of short-term perspective to preserve Spain from flows of immigration, or to trying to improve security, this kind of allegations that the Ministry of Foreign Affairs has issued. But at the end, the key question is that, from a legal perspective, is Spain going to promote a solution in accordance to international law and in accordance to the self-determination of the Sahrawi people? And the only answer to this question is, with this position, clearly no. Okay, so that's my. It's mainly, I must say, as Patricia previously said, that this is my personal point of view. As a lawyer, I have been working in relation to this question, because I have been member of the Asturian Observatory of Human Rights in the Sahrawi region for several years. I have been part of a task force from the General Council of Bar Association in Spain. We had the opportunity to follow several trials against Sahrawi activists in the territory, and I must say that as an Spaniard, it's impossible to look to other side and not recognizing that there is a responsibility as a country with the tragedy of these people. Please add something.
No, more than that.
It's not a question, it's a gift. Our faculty dean, Professor Javier Teruelo, couldn't come because he had some previous appointments, and he asked me to give you this book. We have a research group on gender violence here in the faculty, and we have published the book last year. So let's.
Well, I just listened a little bit about everything you have said and even what you were talking about in your speech. And I was born in Latin America, in Ecuador, and I grew up in Spain, and I had the opportunity to work in Asia. So I think I've been through different countries, different even continents, and I've seen how the people think and respect the human rights, how is the belief of different people. And I think I can say that people, sometimes we forget about how important are the human rights. I have the impression that when ended the Second World War, we were awareness about that we need to focus to build something, and that it was important to have the human rights. Time has been passed. We built something. We are here in Europe. There is a European Union, and sometimes I share your point of view about what you say, that in the Western we see like the problems that is in another part of the countries, in South Africa or in Africa, just crossing the boat even, is not part of us. What is happening in Latin America, from Mexico to South, or even in Canada, is not something that is a problem with us. We have some economic pacts, or we have contracts with Asia, we have contracts with another countries that they don't respect, or they don't have, they don't respect the human rights, or they don't, we exactly know that. But it's okay, because at the end of the day, we need something, because it's economy or it's politics. So I think that sometimes we blind ourselves, because it's more important to have something, to have money, to even sometimes we talk about that we have a system, a justice system, right? But what is going on, or what is happening in Peru, for example, with Fujimori, he's been acquitted. And I heard people, I read a lot of different newspapers where they say, how is this possible? We know what he did, but he's been acquitted. He's 85 years old. So probably this will take another 5 to 10 years, then maybe they go to the International Court, Criminal Court. Probably he will die even, because he has some problems with the heart. So who knows, right? He's been acquitted, but we know what happened. Everybody knows. there are proofs. Maybe there are not proofs that you can go before the court. You can bring to before the court, but there are proofs because there was a lot of suffering, there was a lot of murders, there some people they died, but the family left. Was left. So I think when I hear about it, talking about human rights, many times because I heard a lot of this. I have the feeling that we are not doing our job, actually, that something is being left. I don't know where, but something is being left because at the end of the day, I have a feeling here now studying law that I know a lot of my rights because I didn't study law. But people who's not studying law, they don't know their rights. For example, here we study a lot of, we study about the laws that have the peoples who are not from the UN community, right? But people that are coming from Africa or even from Latin America, they don't know their rights. Even if they have a career, even if they are teachers, professors, most of them they don't know their rights. They don't know, for example, we are talking about Ukraine, what is happening in Ukraine right now. There are a lot of children who's coming with their grandmothers, with their mothers, but even when they have a career, most of them, they don't know their rights. They don't know that there is a law, there is asylum law. They don't know that. Okay, we are happy because most of us are happy because we know that if they cross the ball, maybe there are someone from UNICEF or from another ONG helping them or who try to help them. So I think, and that is my feeling, that sometimes we talking about or we say that we have been or we advance a lot about human rights, but I have a feeling that we have a gap in some place because actually we really don't know a lot of things. We as a student law, yes, but I think outside we don't know. So well, that is my comment. I don't have really a question because all of you have been asking a lot of questions, so that's my comment to you.
Well, I agree with your comment, and I really would urge you as students and as practitioners not to be cynical about human rights. And it's very easy to be cynical. Oh, they're too soft, they don't really exist, they're too Western, what did they ever do? You can't hold anyone accountable. But the fact that we're talking about Fujimori, the fact that you can be outraged, means that there's a basis there. There's a basis of human rights. I'll tell you, in 1919, after World War I, when it was the first time that there was a proposal to try Wilhelm Kaiser, who was the Kaiser of Germany, who had started the war, that there was almost outrage. You can't try a head of state for crimes. They don't owe anything to the international community, maybe to their own citizens. But we can see now, 103 years later, that there have been prosecutions against Milosevic, against Karadzic, against Vlasic, against the head of the president of Rwanda pleaded guilty to genocide. That there's been extraditions in terms of al-Bashir, who was the head of President of Sudan. So all of those things that were imaginable, that were soft, that were cynical, it just took them time to concretize. And it doesn't mean that every instance like Fujimori will win. And yes, there are people who are still getting away with human rights violations and international crimes, but there are other people who we can't see who are checking with their advisors before doing things. There's not one head of state today that will ever stand up and say, I'll rape as much as I want during war. We've passed that threshold. That's no longer permissible. So I would really ask you to understand that human rights, not just as an advocacy tool, but a way in which we want to live in the international community. It is the companion to multilateralism. It's the individual solidarity and collective solidarity that we can have among ourselves.
say that a conflict that erupts in Europe and engulfing the whole continent and inevitably the whole world could significantly challenge the foundation of human rights, or do you think that it is impossible for that to happen right now?
Impossible? Well, you know what we're living through, right? But can it challenge the basis of human rights? Well, yes, but a very strange phenomenon seems to occur after atrocities in war. The law doesn't get weaker, it gets stronger. Remember that it's after World War I that we have the League of Nations, and eventually what's called the Kellogg-Brown Pact, which is supposed to be a pact where nations agreed to resolve their differences peacefully. But then after World War II, only after World War II, do we get the 4 Geneva Conventions? Do we get the United Nations? Do you get the Convention on Genocide? All of a sudden law strengthens, it doesn't do anything. And that we see after the decolonization wars between Europe and its former colonies, that we get the additional protocol, and particularly one that says that international armed conflict will recognize decolonization as a form of international armed conflict and not domestic. So no, I think that as we move into situations at our time that are even more severe and grave due to multilateralism, that we might have instruments that are even stronger. One might predict right now that there's a real issue of, well, what about cyber war? Are we missing an instrument to understand cyber war? There might be even, some future discussion that might look at AI or however. So no, I don't think that the law gets weaker. As a matter of fact, lawyers try and legislate what should have been legislated prior to the atrocities.
Anyone else?
Thank you.